Hi, my name is Ricardo, and today I'm going to focus on part 2 of the Disaster Management Act and non-profit organizations. So this recording is going to be slightly different than the ones that I've done previously. I'm actually going to do an interview with Peter Hendricks from PSA Hendricks and Associates. Peter has been doing a lot of work on non-profit organizations. He's written articles. In fact, we've co-authored a few articles together on governance. So Peter is going to share with us some insights on especially the regulations. So Peter, it is so good to do this video with you. I'm so super excited. This is part 2 of a hopefully 4-part series of videos looking at non-profit organizations and the Disaster Management Act. You've actually written an article, shortly after lockdown started, to help organizations navigate a very complicated scenario in terms of how the regulations apply to non-profit organizations. So thank you for doing this video with me. And I just wanted to add to part 1 of the video, and that's in light of a judgment that came out on the 15th of May, Khoza and others versus Minister of Defense and Military Veterans and others. And I thought the judgment was quite profound. A couple of issues were dealt with by the court, and the judge made some significant comments. Now, the slide that's on currently, it's a quotation from that judgment. And what I'm getting out of that is the judge was basically saying, look, whatever arm of state, there's a common purpose, and that's the citizens of South Africa. And we should always keep that in mind, whether we develop or make the regulations, whether we implement the regulations or even interpret, the regulations. It's important to keep in mind the common purpose, and that is to serve the South African population. So, and I think that that's quite an important remark. Any comments that you wanted to add to that judgment, Peter?
Yeah, absolutely, Ricardo. I think the idea is to fight COVID-19 and not the citizens of South Africa or each other, for that matter. Yeah, so I am very happy for the judgment.
Yeah. No, thank you, Peter. And then another comment that I wanted to make is just to emphasize that our intention is to provide some explanation and clarification where possible on the regulations. This video should not be interpreted as legal advice. There's been a lot of controversy and confusion about the regulations and disagreement as well. The intention on our part is not to comment on whether it's reasonable or rational. In the same way, in the Khoza judgment, the court made it clear that the intention was not to look at the validity of the regulations. Our intention is purely to comment on the content of the regulations. If there's disagreement in terms of the regulations, then the court would be the avenue to pursue. So it's not legal advice, and also what's important to keep in mind is that we're at a point now where the minister published regulations on the 29th of April. Now, those regulations had 3 chapters. Chapter 1 dealt with the definition and application. Chapter 2 dealt with the general provisions applicable during the national state of disaster. And Chapter 3 dealt with Alert Level 4. On the 28th of May, the minister published additional regulations dealing with Alert Level 3. Now, those regulations should be read together. They're not separate regulations because Chapter 2 and Chapter 1 under regulations published on the 28th of April are still applicable. And those shouldn't be read separately. It's all together, except when we look at Chapter 3, it deals with Alert Level 4, and Chapter 4 deals with Alert Level 3. So it's in that context that you know, when we look at alert level 4, where we're at the moment, we cannot disregard chapter 1 or chapter 2. And in fact, the context may change, you know, for certain organizations. So, Peter, I'm going to turn over to you to deal with some of the details in terms of these regulations.
Well, as you said, Ricardo, these regulations um, needs to be read together, and it's very important because I think, just to add to what you're saying, it needs to be understood that the regulations published on the 29th of April repealed the regulations before. The regulations published on the 28th of May does not repeal any regulations before. So when it is interpreted, it has to be read together. Having said that, let's jump into the regulations published on the 29th of April 2020. And we saw that it consisted of 3 chapters. Chapter 1, which has the definition and the application of it. Then we have chapter 2, which sets out general provisions applicable during the national state of disaster. And then we saw chapter 3 that declared alert level 4 in essence, and then also circumscribed alert level 4. Now the 28 May regulations add to it, and that it adds chapter 4. And chapter 4 introduces then to us alert level 3. So what we also need to just bear in mind is that chapter 1 and 2 will apply for the duration of the national state of disaster. That statement in the regulations published on 29 April, that was deleted. Now, let's come to alert level 3. Now, it needs to be understood that alert level 3 opens up our economy a bit more, economic activities. And then in essence, it also opens up what we can do. I have discussed when we were under strict lockdown, we had a article written. It's available on Ricardo's website. I don't want to go into detail about it to go into the explanation of essential service, but I do want to invite you to go and read it, download it from the website and read it, and so that you can at least have a follow on the discussions insofar as it pertains to non-profit organizations. So, going back to work as a non-profit contributor, we firstly have to understand that Regulation 33 says that a person may leave the place of residence, but they may do so to perform a service permitted under Alert Level 3, and we're going to discuss Alert Level 3 in a little bit of detail later. Travel to and from work, buy goods or obtain services except excluded, move children as allowed, exercise between the hours 6 a.m. in the morning and 6 to 6 p.m. as required, attend place of work as permitted, and attend school or learning institutions once. What's important to understand is that whereas under a regulation, under the regulations published on 29th of April, it says that every person is confined to his or her home. We don't see that in Alert Level 3. We just see you may leave your place of residence, but only to do the activities that was already mentioned. Now, in addition to that, Regulation 46 provides that businesses and other institutions may operate except those set out in Table 2. Now, we will discuss Table 2 shortly. And then we also see that Regulation 33 Sub-Rule 4 sets out the following, and this is important, especially for the work of non-profit organizations. Movement of persons between provinces, metropolitan areas, and districts and hotspots is prohibited except for persons doing so in the course of carrying out work, responsibilities, or performing any services permitted under Alert Level 3. And then provided that such person is in possession of a permit issued by the employer with which corresponds, my apologies, with Form 2 of Annex A. Now there's two issues I want to highlight here. And this issue is that, or to expand on the idea of hotspots, because that is going to impact on my explanation further on. And we see under Alert Level 3 that hotspots has been defined, and it means a geographical area or cluster of geographical areas. And then it goes into that as to what has been defined as hotspots for COVID-19 purposes. That's one. And then another important issue to point out is that the work responsibilities and performing any services has to be that is permitted under Alert Level 3. Now, basically everything is permitted except those that has been excluded by the table, which we're going to very shortly refer to. And then secondly is the issue of the permit. Now, the permit to be issued. Now, the permit to be issued is in accordance with Form 2 of Annex A. That was published under regulations on the 29th of April, and it's still the same permit that applies under Alert Level 3, except that there's a difference in how it applies. Now let's have a look at that. When it comes to Table 2, we see that all persons who are allowed to work from home must do so. However, persons will be permitted to perform any type of work outside the home and travel to and from work under Alert Level 3, subject to strict health protocols and social distancing rules, in a way that their return to work is phased in, and in a way that the return to work avoids and reduces risk of infection, and also in a way that work not being listed under the specific economic exclusions in this table is the only work that can be done, okay? However, if you want to travel to a work spot, a hotspot, my apologies, between provinces, metropolitan areas, and districts and hotspots, you are going to need this Form 2. And what's important to point out is that, especially in the context of hotspots, you may find that one area is declared a hotspot and another area not. Now, if an area is declared a hotspot, my apologies, we see the rules make provision that they will be treated differently, maybe to such an extent that a full-on Alert Level 4 is applied, or a varied Alert Level 4 is applied. That being the case, you are going to need, as a non-profit service provider or worker, a permit from your employer. And here we see a copy of the permit that's published. Now, according to Regulation 33(4), like we've already mentioned, the person that must, or where you obtain your permit, is that it has to be issued by your employee. Now, what is meant with your employee is that it is the head of the institution. So the employer, who is the institution, now the head of that institution has to issue it and has to issue this permit. And we see that under the regulations, the head of the institution is defined as the accounting officer of a public institution and the chief executive officer, or the equivalent of a chief executive officer of a private institution. Now, at this point, it is important to also mention that the Department of Trade and Industry has announced that they will be closing the portal. Now, with the previous regulations, there was this online portal where companies that was registered in terms of the Companies Act could go to and obtain permits to in order to perform the essential and permitted services. This is no longer necessary under level 3 regulations.
Peter, can I just briefly summarize, I think, some of the key points that you've mentioned? The one that you've highlighted is that even though there's now a wider range of operations that may commence under alert level 4, if your employees can work from home, then they should, or they must, in fact, that's what the regulations say, they must work from home, because the more flexible alert level doesn't mean that the risks are removed. There are still risks, and in fact there are cost implications in implementing those protocols and measures. The regulations specifically require employers to have a phased-in plan, which we'll deal with in the next video. So that's an important issue to consider for organizations, to what extent employees should go back to work, and that, if they can work from home, that should be the first option. So that's a very important aspect that you've highlighted. Secondly, the whole issue of the permit. It's not all employers that will now be required to issue permits under the regulations. And so, it's not, even though it's permitted to render these services, organizations will have to consider how they're going to do it. And if they do decide, they must ensure that there's compliance with those requirements. Also, what you mentioned more recently is that to some extent there's now been more certainty in terms of the who issues the permits, because under the Chapter 3 Alert Level 4 regulations, there's been a lot of confusion as to who issues that the actual permits. So you're saying the regulations are saying that's now issued by the employer in the limited instances required for it to be issued by the employer.
Absolutely, Ricardo. Now, we see also that in Regulation 46 of Chapter 4, it says that businesses and other institutions may operate except those set out in Table 2. Now, what it really says is that all services and goods are permitted except for those stated in Table 2. And if I just quickly scan through it, it is the consumption of food and beverages at or in a place of sale. And this would include restaurants, convenience stores, or informal traders. But I have to mention that there's been a case where the High Court has ruled that that those informal traders at the Grand Parade in Cape Town, those that do perform essential services, may start trading again on this flea market. So it's been a court case that has given that permission. Then we see that on-site consumption of liquor, short-term home sharing, letting, leasing, rental for leisure purposes is not allowed. Domestic passenger or travel for leisure purposes is not allowed. passenger ships for leisure purposes, conferences and events, including sporting events, except as provided for in Chapter 4 of the regulation, personal care services, including hairdressing, beauty treatment, makeup, and nail salons, and piercing and tattoo parlors, except those categories of services identified in directions of the relevant cabinet member. Um, we see, as mentioned, conferences and events, including sporting events, except as provided for in Chapter 4 of the regulations. We also see personal care services, including hairdressing, beauty treatment, makeup, and nails salons, and piercing and tattoo parlors, except those categories of services identified in directions by the relevant cabinet members. Now, to stand still at this point, there has been challenges on the issue of hairdressing, right, Ricardo? Um, and there was some decisions that was made that's pertinent. Can you just expand on that?
Yes, Peter. My understanding of the judgment is that there was an application brought to include, hairdressers under this services that should be permitted under alert level 4. Um, Unfortunately, the application was denied, and the reason for that was because the Minister of Cooperative Governance, Minister Dlamini Zuma, was not cited um, under the application. And keeping in mind that the minister is actually the minister responsible for making the regulation. So I mean, the part that you read now, Peter, those are part of the regulations made by the minister. So the court was basically saying, if you want to address the regulations, you need to cite the appropriate minister in order to respond to that. So it's been sort of kicked out on a technical matter, but I suspect that the application will be brought back to court, with the correct minister being cited. So, we'll see how the court will deal with this particular issue.
Okay, excellent. Then, continuing with the list, we see that exclusions relating to public transport services is set out in the directions issued by the cabinet member responsible for transport. It's also listed. Exclusion relating to education services is set out in the directions issued by the cabinet members responsible for education. Tourist attractions, casinos, and entertainment activities, except those categories of activities which the relevant cabinet members, in consultation with the cabinet member responsible for health, identified in directions as safe to resume under specified conditions. So even though we have this table, there will still be directions that is to follow insofar as permitted service is concerned, and we would just have to keep an eye out and see how those directions impair or enable nonprofit organizations. Another important factor, Ricardo, is the fact that many nonprofit organizations are operating schools. Now, this has also been provided for. We see in Regulation 34, Sub-Regulation 5, that it provides that any learner or student must be issued with a certificate which corresponds with Form 3A of Annexure A by the head of his or her school or institution of higher learning, or a person delegated by him or her, that the learner or student attends that school or institution of higher learning for purposes of travel between provinces. Now, this is an important aspect that nonprofit organizations that has education programs has to take into account to ensure that their learners can attend their education programs. Then one last aspect I want to touch on, Ricardo, is the issue of gatherings. Now, Regulation 37(1) provides that all gatherings are prohibited. And then it says, except, and I'm only going to touch on two of these. A, faith-based institution, which is limited to 50 persons or less, depending on the size of the place of worship, provided that all health protocols and social distancing measures are being adhered to as provided for in directions that must be issued by the cabinet member responsible for cooperative governance and traditional affairs. And then to um, gathering at a workplace for work purposes.
So, Peter, similar principle that's applicable in this context. The minister, Dlamini Zuma, also said that um, even if the organization is permitted to gather, it doesn't mean you have to. It's not an obligation; it's a permission.
Yes.
And so, before organizations, engage in these gathering activities, they need to consider, the risks and the protocols involved, in the or applicable in this particular context. So that's the responsibility on the employer or the organizations, the board members, and they must not make these, take these decisions lightly. So it's very important to, to have a holistic approach to this.
Yeah, absolutely, Ricardo.
So thanks for that, Peter. In addition, I just want to mention that, under Chapter 2, that's applicable during this national state of disaster, certain cabinet ministers have been given the authority to issue directions. In this context, I want to refer to two instances where that kind of authority has been granted. The one is in relation to the cabinet member responsible for social development, and the regulations provide that the minister may issue directions to address, prevent, and combat the spread of COVID-19 in all Department of Social Development facilities, and also may vary those directions. I know there's been a lot of controversy and even a judgment that came out recently on the issue of food distribution. I think if I look at these regulations, it's quite limited, in terms of social development. There's also a authority that's been granted to all ministers or cabinet members, or any cabinet member may issue and vary directions as required within his or her mandate to address, prevent, and combat the spread of COVID-19, its impact on matters relevant to their portfolio from time to time as may be required, including, then the examples are listed, dissemination of information required for dealing with the national state of disaster, implementing emergency procurement procedures, and taking any other steps that may be required to prevent an escalation of the national state of disaster. So ministers are given some authority to issue directions, and directions have been published under the regulations. More will be published, so there will be additional requirements applicable to non-profit organizations in all likelihood. And so it's important for organizations to take those directions into account in light of the existing regulations, and to ensure that there's compliance with those requirements. These regulations and directions are changing fairly rapidly. So anybody watching this video must take into account that things may change at the time that you're watching this video, and there are additional requirements for organizations to consider. Ultimately, it's about protecting the citizens, protecting the employees. And so we hope that this video has been helpful. And thank you so much, Peter, for your comments, your insights, and the preparation that you've done in the run-up to this video.
Thank you very much, Ricardo, for including me. And yeah, I really enjoyed it.